I'll go ahead and start the recording. Okay, again, welcome to today's session on how to get a green card with the U.S. Citizenship and Immigration Services. This webinar is going to have a speaker that we're delighted to have here today from the U.S. Citizenship and Immigration Services, who will provide an overview of various pathways to permanent residence in the U.S. And topics will include humanitarian programs, family-based immigrants, and employment-based immigrants. And the speaker today, whom I'll introduce shortly, will also be available to answer any non-case specific questions during this session. Before we get started, I did want to share a few housekeeping items. One, as I mentioned earlier, we are recording this presentation. All participants will be on mute until the end of the presentation when we will open it up for Q&A. There will be a few ways to do Q&A. You can put your questions into the chat box. You can also submit it in the Q&A box, or you can raise your hand and then we will unmute you so you can ask your questions that way too. So without further ado, I'd like to introduce our guest speaker, Willie Giacofci. Willie is a community relations specialist for the U.S. Citizenship and Immigration Services in Northern California. He provides trainings and information on immigration benefits administered by USCIS. He previously worked as a congressional liaison and an asylum officer for USCIS in San Francisco. Thank you so much, Willie, for joining us, and I will now turn it over to you.
Thank you so much, Priya, and thank you to the Palo Alto Library for inviting us to present on a very important immigration topics today. I'm going to start by sharing our PowerPoint today. And let's see if this... All right. So like Priya mentioned, we are going to be discussing various pathways to permanent residence status, also known as a green card. Just as Priya mentioned as well, today all lines are muted. However, we will take some questions at the very end of today's presentation. Today's presentation is not intended for the media or members of Congress. If you are a member of the media or a member of Congress or a staffer, please feel free to reach out to USCIS through the email addresses displayed on the screen today. Additionally, today's presentation will of course be recorded. And if you do have general information or general questions about immigration topics, please feel free to reach out to USCIS at our North CA Community Relation at uscis.dhs.gov. This is our disclaimer for folks as well. Today's presentation is not intended to provide legal advice concerning immigration matters. It is based solely for educational purposes and outreach purposes. And none of the advice today or none of the information today can be relied on as legal advice. All right, so to begin, I just wanted to give a brief overview about U.S. Citizenship and Immigration Services, or also known as USCIS. USCIS is a federal agency that oversees lawful immigration into the United States, whether that's through the issuance of visas or through other non-immigrant means to enter the country. So when we're discussing today's agenda, we're going to first discuss the different pathways or ways to obtain permanent residence status in the United States. I'll also provide an overview of our USCIS online accounts and also some helpful resources and tools to help you on your immigration journey. All right, so to begin, permanent residence or obtaining a green card. There are several different ways or methods to enter the United States or to adjust status as a permanent resident. Namely, we have our humanitarian programs, we have the diversity lottery system administered from the Department of State, but mostly we have folks. Yes.
I'm sorry to interrupt. It's still on the first slide.
Oh, okay. Oh no. All right. Has the slide advanced?
No, it looks like it has not.
Okay.
Maybe if you want to go to slideshow view.
All
Okay,
right.
there we go. Now it's on the U.S. Citizenship and Immigration Services slide, your fourth slide.
Okay. So has this advanced at all?
Now it's on the agenda.
Okay, perfect. All right. Sorry about that. Um, and I'm hoping our PowerPoint has updated now.
And now it's permanent resident equals green card.
Perfect. Okay. So like I mentioned before, we do have various programs, including our humanitarian programs, which include our asylum and refugee programs, the diversity lottery system. This is administered by the Department of State. We also have our family-based immigration petitions and our employment-based immigration petitions. At USCIS, the majority of our petitions that we process are usually family-based, so relatives of US citizens or permanent residents entering the United States. If you are attempting to enter the United States or adjust your status as an immigrant, there are two ways to immigrate. First, there's adjustment of status. This is the pathway to permanent residence for people who are residing inside the United States. Generally, people are on some sort of non-immigrant visa if they enter the United States, and then they adjust their status to permanent residence. However, if you're residing outside of the United States, you can apply for consular processing through the Department of State to enter the United States on an immigrant visa. The main petitions, as I mentioned, are our family petitions and our employment petitions. When it comes to family-based immigration, this is really the bread and butter of United States Citizenship and Immigration Services and the kind of petitions we process. Depending upon if your family member is a US citizen or a lawful permanent resident, there are various different family members whom they can petition for. For instance, if you are a US citizen, generally you're able to petition for any sort of unmarried children under 21, married children who are over the age of 21, spouses, siblings, and also parents. However, if you're a lawful permanent resident, there are smaller categories which you can petition to enter the United States. For instance, spouses of permanent residents, or any children who are unmarried, whether they're over 21 years old or under 21 years old. Regardless of whether you are a permanent resident or a US citizen, the first step in the immigration journey would be filing a Form I-130. These are alien relative petitions. The Form I-130 establishes the family relationship between the US citizen or LPR and their family members. This does not grant any sort of benefit to the family member who's residing abroad or who is seeking to enter as an immigrant to the United States. It only establishes the family relationship and also gives you the most important thing, your priority date, which is a place in line for a visa if you are filing under one of our categories which require a visa to enter the United States. Okay. When it comes to categories of family-based petitions, there are some family members who need to wait for a visa to become available before they're able to adjust to permanent resident status or to immigrate to the United States on an immigrant visa. If you are an immediate relative of a US citizen, so a spouse of a US citizen, an unmarried child of a US citizen, or a parent of a US citizen, there are always visas available for you to immigrate to the United States, which means that you don't have to wait in line for a visa to become available. However, if you are a family member that is not an immediate relative, then you do need to wait for a visa to become available to either adjust status or to immigrate to the United States. And we call those folks our preference categories. When it comes to preference categories, on the U.S. Department of State's website, we have a visa bulletin, and these list all the family visa preference categories. And so these are unmarried sons or daughters of United States citizens. We have spouses and unmarried children of permanent residents. We also have married sons and daughters of U.S. citizens and brothers and sisters of U.S. citizens. Depending upon your filing category, you would need to monitor the visa bulletin to establish when you can apply to immigrate to the United States on an immigrant visa. As far as the visa bulletin goes, this visa bulletin is administered by the U.S. Department of State. Each month, the visa bulletin is updated to establish how many people or how many visas are available to enter the United States. When you file an I-130 petition, you receive a priority date, and that priority date secures your place in line to wait for a visa to become available. If your priority date falls before the date on the visa bulletin, this means that there is an immigrant visa available for your family member to adjust status or immigrate to the United States. This is an example of the visa bulletin, which is updated each month. And as you can see, sometimes there are extended wait periods for specific categories. One of the longest wait periods is probably our brothers and sisters of U.S. citizens are under our F4 category. And this just means that sometimes you might have to wait up to 20 years for a visa to become available for one of your family members. And each year, there are new visas that are available for family members to immigrate to the United States. And all those updates will be online through the travel.state.gov website. If you are petitioning for a family member to enter the United States, we just want you to know that family members of U.S. citizens and family members of permanent residents, those folks in those categories are subject to the public charge ground of inadmissibility. When somebody immigrates to the United States or adjusts status to permanent residents, USCIS needs to determine that the person immigrating is not likely to become dependent on the government for long-term subsistence, which just basically means that we're just examining to make sure that this person will not become a public charge in the future. There's a very diverse amount of categories and factors that USCIS examines to make that determination whether somebody is likely to become a public charge. Mostly, we're just investigating whether this person has received significant cash assistance in the past or whether they've been institutionalized in government expense in the past. We would like you to know that while we do consider public benefits under the public charge and admissibility calculation, there's not one single determining factor. It's a totality of the circumstance approach. So USCIS is looking at the person and their entire history and all their factors that lead into this determination. So we do want to let you know that there are definitely certain categories of immigrants, such as asylees, refugees, who are not subject to the public charge and admissibility. So we're not even examining those specific categories. And if you do receive public assistance in the past in the United States, while USCIS will examine the receipt of benefits, it's not determining or a determination that you would be subject to the public charge of inadmissibility. In addition to our family-based petitions, we also have our employment-based petitions. Instead of filing a Form I-130 petition, an employer would submit an I-140 petition on behalf of the person immigrating to the United States or adjusting status. For the I-140 petition, this is all dependent on the employer. So the employer is the petitioner in this circumstance. Generally, when somebody is applying for a green card based on employment, they would first need to meet specific job offer requirements, employment and education experiences, and various different investment or business calculations, which we are determining beforehand. Sometimes there are specific categories of employers or employees who can self-petition to enter the United States on an immigrant visa. These are pretty specific categories, and I'm going to address those in the next slide. But just note there are some very specific professionals who can apply to self-petition to enter the United States on an immigrant visa. And so these are a list of our employment-based visa categories. As you can see, they're ranked by 1, 2, 3, 4, and 5. So depending upon your education background, depending upon your professional background, you could fit into specific categories. These are all determined on the I-140 petition first to determine whether you can immigrate on a specific employment visa. But our EB1 preference, we like to think of these people as our extraordinary and outstanding professionals, such as professors or researchers or executives. Our EB2 category, or our second preference categories, those are professionals with advanced degrees who have some sort of exceptional ability in the arts, sciences, or businesses. Our third preference are professionals or skilled workers who are applying to enter in some sort of professional capacity. I like to think of a lot of our folks in Silicon Valley as applying under our EB3 category, so a lot of our software engineers fit into this category. Our fourth preference category are our special immigrants, such as certain religious workers. And these folks can be missionaries, or they could be working in some sort of religious capacity. And finally, our fifth preference, or EB5, and immigrant investors. These folks are investors who invest a significant amount of money into the United States economy to create a business and to create job growth. So they have to invest at least $1 million into a business, and they also need to show that they've created a certain amount of U.S. jobs based in the United States. I also want to briefly touch on the diversity immigrant visa program. This is also colloquially referred to or popularly referred to as our visa lottery program. But please note that the diversity immigrant visa program is administered by the U.S. Department of State. USCIS, while we grant green cards and permanent residence to diversity lottery visa winners, the program is actually administered by Department of State. There are 50,000 individuals who are selected randomly through the lottery system to become a permanent resident or to enter the United States on an immigrant visa. If the individual is residing outside of the United States when they're selected for the visa lottery, they would consular process and immigrate from abroad to enter the United States. However, if somebody is selected for the visa lottery and they are currently in the United States and they are residing in some sort of lawful status or in a non-immigrant visa, then USCIS will process their adjustment of status application to enter to become a permanent resident. Please note that the Diversity Lottery's immigrant visa program was set up for countries with low rates of immigration to the United States. It's administered regionally, so the main benefactors of this program are usually immigrants coming from entering the United States from Africa or from Central Asia. All right, we're going to next address some of our humanitarian programs that lead to permanent resident status in the United States. These are outlined in our programs in bright green. These are our special immigrant juveniles, refugees and asylees, folks who receive protection under the Violence Against Women Act, and our T and U visa holders, and we'll address each one of these programs. You might also be aware of other programs such as parole programs, TPS or temporary protected status, or our DACA or deferred action for childhood arrivals programs. While those do lead to at least a temporary ability to reside in the United States and work in the United States, DACA, parole, and TPS do not lead automatically to permanent resident status. All right, so when it comes to special immigrant juveniles, the SIJ program was intended to help children under the age of 21 who have been found by a state court of being either abused, abandoned, or neglected by at least one of their parents. If the state court finds that the juvenile meets one of these criteria, then the juvenile is able to apply for permanent resident status and a Form I-360 or SIGA application. Usually in these cases, the juvenile is not able to be reunited with their family member or parent who has been found to have either abused them, abandoned them, or neglected them. I will say that while this does permit a juvenile to adjust status or become a green card holder in the United States, the juvenile cannot petition for their parents to enter the United States on an immigrant visa or through adjustment of status. Please note that the SIGA finding is first determined in state court to make that finding in family court. And then USCIS will be able to adjudicate their I-360 petition to determine if they meet the requirements for as an SIJ or special immigrant juvenile. After they do receive their approval for the SIJ program, then they are able to apply for permanent resident status. As you know, asylum is available for people in the United States who are claiming that they are unable or unwilling to return to their country of nationality. Generally, this is based because they've suffered some sort of harm or past persecution in their home country, or that they fear harm in their home country if they return. In order to qualify for asylum, the applicant must fear return or persecution based on one of the 5 protected grounds. So this is basically due to their race, religion, nationality, political opinion, or membership in a particular social group. If granted asylum, the asylee may reside and work in the United States. They can petition for their family members, and they can apply for permanent resident status after 1 year. The asylum program is administered by USCIS at the asylum offices located throughout the United States. If somebody is residing abroad and they're looking to enter the United States because they fear persecution or harm in their home countries, then they would be applying for refugee status to enter the United States. So I like to think of refugees are residing abroad while asylees are residing inside the United States when they seek protection. Under the Violence Against Women Act, there are certain family members who've been abused or been harmed by their US citizen spouses or family members, or their LPR or permanent residence family members. VAWA provisions protect abused spouses, children, and parents of US citizens, but also abused spouses and children of permanent residents. So for instance, if somebody is married to an abusive US citizen, they would need to submit an I-360 petition to qualify under the Violence Against Women Act provisions. If their I-360 petition is approved, then the person is able to apply for permanent resident status in the United States. And they can also work permanently in the United States if they qualify under this protection. While the act is called the Violence Against Women Act, please note that these protections or VAWA applies equally to both women and men who have been abused by certain spouses. When it comes to our TRU non-immigrants, these are special protections afforded to victims of human trafficking or to victims of certain serious criminal activity in the United States. As far when it comes to the T visas or trafficking visas, these are folks who have suffered or have entered the United States because they were subjected to some sort of either sexual trafficking or through labor trafficking. To qualify for these protections, they would first need to file an application with USCIS. If their application is approved, they can then apply for permanent resident status within 3 years. The U visa program, or U non-immigrant status, is afforded to victims of serious criminal activity in the United States. If someone has been a victim of a crime in the United States, and if they are currently assisting in the prosecution or investigation of that crime with local law enforcement or with a district attorney's offices, then they can apply for a U visa. If their U visa application is approved, these folks and their family members are able to apply for permanent residence status. But please note that there are only 5,000 T visas that are granted each year, and there are only 10,000 U visas granted each year. While somebody is waiting for a visa to become available and they qualify for the programs, what they'll be given is a deferred action, which lets them work and reside in the United States legally while we wait for a visa to become available. I also wanted to highlight one of our newer programs called Keeping Families Together. This was introduced by President Biden in June of 2024. This is a program that's specifically for spouses and stepchildren of US citizens who've been present in the United States for the last 10 years before June 17th, 2024. In order to qualify for this program, the spouse or stepchild of the US citizen must not have entered the United States legally and entered the United States without admission or parole. Certain criminal convictions may disqualify a family member from being able or eligible to enter the United States under this parole program. But those are all outlined on our Keeping Families Together website, which is included on the slide below. If somebody is approved for parole in place, then they are granted parole for up to 3 years. They can obtain a work permit, and then they can also apply for permanent residence after their parole is granted. Please note that USCIS is subject to current litigation right now in federal court, which does not permit us to adjudicate or approve any pending parole in place applications under the Keeping Families Together program. This stay remains in effect through November 8th, 2024, and hopefully we are able to update everyone after that November 8th deadline. But please note that people are still able to submit their parole in place applications online by filing a Form I-131F application. We will still schedule people to appear for their biometrics or fingerprints at our application support centers. However, we are still unable to approve these cases until the federal litigation is resolved. I know this is a lot of information. There are many different parole programs, there are many different humanitarian programs, but please note that some of them do not lead to permanent resident status by themselves. I just want to highlight some resources and tools available on the USCIS website that are available to all of you. First and foremost, applicants and petitioners may create a USCIS online account on our website. And in order to create a USCIS online account, you will need to sign up and log in However, through your USCIS online account, you would receive automatic updates on your cases that are submitted to USCIS. You would have the ability to reschedule any sort of biometrics appointments. You would receive all of your receipt notices, interview notices, and any sort of requests for evidence through the online account system. And you can also upload or any sort of additional evidence through your online account to any pending petitions or applications. And probably the most important aspect of the USCIS online account is the ability to change your address with USCIS almost instantaneously through the account. USCIS does require people to update their address within 10 days of moving so that you're able to receive the most up-to-date information on your application. I also want to highlight some of our customer service tools. So on our website, which is uscis.gov, which is also available in Spanish, you can check the case status of your pending applications or petitions. You can also go in to change your address or find out more information about how to change your address. You can check our most up-to-date processing times or any sort of pending petitions or applications so that you're not always constantly wondering how long is this application or petition going to be pending before I receive adjudication. We also include a lot of information about how do I guides and self-help resources about the immigration process, whether you're applying for or petitioning for a family member to enter the United States as a permanent resident. And also we can download forms online and receive the most up-to-date information about the instructions for how to fill out our forms and applications. And of course, if you do have questions about any of the USCIS programs or a pending application, we do direct folks to the USCIS Contact Center, which is listed on the slide today, 1-800-375-5283 for the most up-to-date information about your applications or petitions. All right. When it comes to applying for applications or petitions with USCIS, if you do have questions, we would direct you to our Avoid Scams website, which will include a list of all the legal service organizations in your specific area. This list is very helpful because you can receive a consultation from an accredited representative from the Department of Justice who is accredited to provide legal advice about immigration applications and petitions. Additionally, attorneys are also able to provide legal advice. However, notarios or unlicensed immigration practitioners are not able to provide you legal advice about what petitions or applications you're eligible for. Also on our Avoid Scams website, it includes information about how to report any sort of current fraudulent schemes in your area or that you've heard about or been a victim of. These are very important for us to understand what's happening in your current region or your area, or if anything has happened to you in the past. And then finally, we do have our form filing tips that are also included on our uscis.gov Avoid Scams website. I know this is a lot of information and we covered a lot of topics today. We are going to discuss some of these. And of course, please feel free to raise your hand as well if you do need to ask a question.
First off, thank you so much, Willie, for such useful information on the topic of getting a green card. We really appreciate you sharing that information with everyone. I'm going to go ahead and stop the recording.